there's been the change from collaborative law to collaborative divorce or collaborative practice. And it started with collaborative law, I mean just strictly lawyers sitting around the table. And I mentioned that early on that made that trip to Santa Cruz and talked about collaborative law. And here were these people that were looking at doing collaborative, what they called collaborative divorce, where you use not just the lawyers, but coaches, mental health coaches, financial people, and child specialists. And this was Nancy Ross and Peggy Thompson. And I got really excited about that. You know, here was, and what happened with them is they were trying that, and they were taking cases in from the client, the coach's stamp level, and working with the parties, getting them. They often were lawyer averse, and we're working with them from a standpoint of getting them ready to be able to go to lawyers. So they do what they do their work, and they send it to the lawyers, and the lawyers would shoot it down. They didn't have, so for them, the idea of collaborative law was a perfect fit. So that's where it started. And there are still lawyers that say they just want to do collaborative law. Others that get really excited about working with the teams. And then there's other movements where there's only one coach instead of two, and the one coach becomes more of a leader and help mediate things. I had a case right in this room a couple of days ago where our financial person we were at a five-way meeting. Financial person led the meeting and working with the financial people, financial information, projecting it onto the board and getting agreements by the parties. So the lawyers were there, but not being the ones who were primarily active, were there to support what was going on, but not being the ones who were active. It worked extremely well in that particular case, and the clients were very, very models almost to make that one work. So I've been involved with collaborative divorce trainings, helping people do that. One of the things that's really important, there was a woman from Canada who did a 3-year study, got a grant and did a 3-year study on collaborative law and collaborative practice. And one of her conclusions is the importance of avoiding orthodoxy, where you say, this is the way to do it. This is the way. So collaborative law is the only way to do it. Collaborative divorce is the only, collaborative practice is the only way to do it. 2 coaches is the only way to do it. 1 coach is the only way to do it. Forget it. You know, there's all different kinds of ways you can do it. The one thing that I insist on from my own standpoint is there's only one rule, and the one rule is a disclaimer. The one rule is you got to get out if it doesn't settle. If you try messing with that one, you're back into the litigation mix. But it's interesting how many times people want to fool around with that one. You know, well, can't we just stay in there if we work with somebody else from our firm or something like whatever? They try to find some other ways to do it. But the main thing, that's the one rule. There's only one rule, and after that, there's all kinds of creative ways that we can work to help people work through this process. And I should add that we've talked about divorce, but you know, collaborative law is perfectly suited for civil law, all kinds of practices. It's just harder for some reason to get in. It hasn't been wildfire spread like family law. It's been harder to get civil practitioners to buy into it. If someone called me and wanted to inquire about how to get started with collaborative law, here's what I tell them. This is a fairly frequent thing. I said, don't go someplace else to take a training, because you're going to then come back and have to be a missionary to try to get other people involved in the process. Find a dozen people or so, lawyers or people in your who would be interested to hear about it and to get and be able to get a CLE, legal education credits for it perhaps, and then have a trainer come in for a 1 or 2 day session. And what happens then is you almost invariably you've got your system, your local group all set by the time that training's over. I did a 1-day one in Ventura, California for 9 people around a little board of directors room, and by 2 o'clock in the afternoon they were talking about articles of incorporation, how to do this, who's going to do that. You know, they weren't listening to me anymore. They were all excited about getting started with it. You know, I said, wait a minute, you got to get the training first. But you know, it's what happens is you've got the people around there that it's like our 9 people around the potluck. It's like the same thing. They get excited about it. And by the time most trainings, the first couple hours, there are certain people who are skeptics, and they're asking a lot of skeptical questions, a lot of what ifs. You know, what if this? What if that? By the noon of the first day, generally, you can see the change in them. You can see that it's beginning to seep in what this might mean for them in their practice. And honest to God, in many cases, you can see their faces change. The faces soften up when they start thinking about not having to go to court, not being involved with all that nasty litigation. They can have something where they could work with people, help them settle things, that they start easing up. I had a gentleman probably a little bit younger than I was in the training in New York, Manhattan, and he was pretty what ifs to start with. By noon, I talked to him at the break, and he said, you know, I can see where I could keep doing this. I wouldn't have to give up my practice when I reach age 65 or whatever. This is something I could continue on because it doesn't have the stress level that litigation has. So those kind of thoughts start working with people that have seen how their lives might be different. And of course, there are always people that don't want their lives to be different, and that's okay. You know, and then I say I'm glad to have good litigation lawyers out there to refer things to. So keep doing that. You know, if you like it, keep doing it. But then, if you don't like to do that, there's other options for you. My life is a joy after that. Now I practice in my home for the last 10 years. I office in my home. I come to the Collaborative Alliance Center for conferences. And it's just helping people. And the thing that's different, the main thing that's different is, you know, our litigation, the responsibility and the focus of promoting and accomplishing something are with the lawyer. With collaborative law, the focus is on the clients, and you're there to help the clients, but you're not taking it on. And every so often now I see lawyers, particularly young lawyers who are in collaborative law, who have not made that shift totally. So they're still hanging on to the fact that they've got to make this happen. They've got to get the result that their client wants. And I tell them, pay attention to your body feelings. When I'm doing that, all of a sudden I notice that my stomach is tightening up. And that's a signal to me to back off and be supportive of what's going on, but not to try to make my thing happen with them. And they're still struggling, the young lawyers who are still hanging on are struggling with that same pain and suffering almost, that when they can't get their result to happen.